Okay, so let's shift focus now to the provisional measures. We spoke about it at the beginning. So what is the current stance of national laws on granting arbitration or arbitrators the power to issue provisional measures? And also let me ask the second question with it, because I'm sure it will be connected. Do you think that the enforcing of these provisional measures as a final award could deprive parties of their rights to appeal?
Excellent questions again, Saad. Thank you very much. The current state of national law with respect to provisional measures by arbitral tribunals is fairly uniform. Historically, there were a number of jurisdictions that denied arbitrators the power to award provisional relief. That has changed fairly radically. First, national laws outside the UNCITRAL model law began to give arbitrators expressly the power to order interim relief, the same way a national court would have the power to order interim relief. Courts in the United States, elsewhere, led the way in doing that. The model law began by doing that, and then in more extensive revisions authorized explicitly arbitral tribunals to grant interim measures without prejudice to the power of national courts, also concurrently in parallel to grant interim relief in aid of arbitration. So that means that the parties' arbitration agreement gives presumptively the arbitral tribunal the authority to order provisional measures, but it doesn't take that away from national courts. And the model law, to some extent, like national law in other jurisdictions, again, the United States in particular, but other jurisdictions also, I think of India and Singapore, recognized the authority of national courts to enforce orders of provisional measures, albeit on an interim basis. Arbitral institutions acted to reinforce the ability of the arbitral process to provide interim relief, and established mechanisms typically called emergency arbitration, whereby even before an arbitral tribunal is constituted, a sole arbitrator, a so-called emergency arbitrator, could be appointed on a very fast-track basis, i.e. in 2 or 3 days, sometimes less than one,